Good afternoon, everybody. I'm Graham McKirk. I'm the immigration law expert for IRG for England, and I'm proud to be a member of the Global Mobility Committee. With my colleagues who are all on this call. The Global Mobility Group was established to develop interaction between IRG members who are interested in any aspect of global mobility, for example, employment law, immigration law, tax law, social security law, but indeed any other area of law that comes into the ambit of global mobility. And the group's been established for 2 or 3 years now, but we're always looking for new members to join us. And today we thought we would use this opportunity to discuss a sort of classic global mobility issue with an intercompany transfer. And we have a case study, which I'm not quite sure where that is, but can we put that up? Thank you.
Yes, I will do it for you now.
Lovely.
Hopefully you can all see that soon.
Okay. So we have a sort of major Chinese IT company, which has got a subsidiary in your country, basically, and it wants to do the following things. It wants to appoint a Chinese resident national to the subsidiary board of directors as a non-executive director, required to travel to your jurisdiction 4 times a year for board meetings. Also wants to appoint a Chinese national as managing director of the subsidiary for a term of 5 years. And thirdly, second a senior manager from China to the subsidiary for a maximum period of 6 months. And each of those examples raises global mobility issues. They each raise immigration issues, and what the idea is, once we go into our breakout sessions, that we will each hopefully have a group of people who can discuss the case study from a number of different viewpoints. So I'd like to pass across to Stephanie to make some initial comments from her perspective.
Yeah, thank you, Graham. So my name is Stephanie Leman. I'm from Paris. I'm a partner in a law firm called Galahad that specializes in global mobility. So originally I'm more a tax lawyer, but now I do a bit of everything. And so since Madeline is not there today, I will step in for the employment issues that may arise with respect to this case study. So obviously my comments will be very general. I think that during the breakout session, we will be able to discuss a bit more in depth about the employment topics that could arise in any of your jurisdictions. And I will be able to talk about the French ones. But more generally speaking, regarding this case study, I would say that for the first question related to the appointment of a Chinese resident national to the board of directors of the subsidiary as non-executive director, one of the main questions would be, are they employees in your jurisdictions? So non-executive directors, how are they treated from an employment law standpoint? Is it a topic or not? And is there something to do from an employment law standpoint, or is it purely corporate law? That's something we will be able to discuss. For the second point, that is the appointment of also a Chinese national as managing director of the subsidiary. Well, it's kind of the same question. Is it purely a corporate appointment, or can a managing director be an employee in your jurisdiction, or can he be both? And in this case, what would you advise the client to do for this managing director? And third, with respect to the secondment or posting of a senior manager to the subsidiary for 6 months, that would mean, strictly speaking, that this employee will remain under an employment contract with his original employer from his home country. So we will have to discuss what would be the obligations of this employer in the home country, while posting this employee to the host country. So what would be the part of the host country legislation that would be applicable to this employee during this posting? Are there some specific formalities, for example, if it's a EU member, the host country is a EU member, then there's the posting directive that provides for lots of formalities to be carried out for this posting. So this is something we can discuss, and for how long will it be, there's obligations, etc. So that would be pretty much it for the employment side. But obviously, if employment specialists that are here think that I forgot things, I will be very happy to hear it.
Thank you. Thank you. So can we pass over to Kavita now to talk, I think, a little bit about social security aspects?
Yes, thank you, Graham. My name is Kavita Sukransing. I work for Accountancy in the Netherlands. And compared to labor law, the social security issue is quite more or easier compared to the labor law perspective. Basically, the main rule is where you work, that's where you are socially insured. And within the EU, we do have a directive which states in which country you are socially insured if you work in different kind of countries, or if your employer is in different country compared to your home country. And if there is, as is the case right now, a national from outside of the EU, some countries, for example, the Netherlands, have a lot of treaties regarding the social security with those specific countries. So depending if there's a tax treaty or the EU directive, you are socially insured in one country. So during my breakout session, we can talk about migration, tax, or social security, which basically are my point of view. That was it in short. So Tommaso from Bacchiardi can take the tax.
Yeah, thank you, Kavita. Hi, everybody. Good afternoon. My name is Tommaso Fonti. I am a tax lawyer and a partner at Bacchiardi Partners. I deal with, let's say, global mobility implication from different angles. I've been dealing with global mobility since 15 years so far. And I have the role, and I am in charge of briefly provide you with some insights and comments regarding the tax implications that this kind of case could have, let's say, in the host jurisdiction, in the hosting country. I believe that tax implications here depends on how the relationship with the hosting company is actually structured. So in order to determine the tax treatment of the flow of income, it is essential to understand whether the individual, as already Stephanie told us, is purely appointed as a member of the board of directors, so a director, or it is also an employee. Because understanding the relationship underneath the assignment is of utmost importance to understand whether Article 15 or Article 16 of the double tax treaty, so the convention in force between the sending country and the hosting country, treat is applicable, and therefore treat the taxation of the flow of income. Briefly speaking, from the, let's say, the Italian side, I can say that question number one, it is quite straightforward that it is a mere appointment, and therefore Article 16 of the Double Tax Treaty applies, and the hosting country should have the right of taxation. Question number two is instead a gray area, because it is essential to understand whether it is only an appointment as a director or also an employment relationship. Instead, the question number three, since we speak about the secondment of a senior manager, it is highly likely that there is an employment relationship, and therefore Article 15 and of the Double Tax Treaty should apply, and the tax implication must be assessed in accordance with Article 15 of the Double Tax Treaty. We can for sure deepen the analysis and address every matters and every aspects within the breakout session room.
Perfect. Thank you very much, everyone. Right, what I will do is I'm going to stop sharing my screen now. So shortly, we are going to break off into your breakout room. Now, the room that you will be put into, we will stay in that room for 40 minutes. So you get to have a good discussion between yourselves. We will then come back into the main room for the last 5 minutes of the session, just to have a recap of everything. Now, Flavio and who are with us today have very kindly offered to step in and help out with one of the breakout rooms. So thank you to you both as well. I just want to quickly thank you, our sponsors, for the virtual event Blumenthal 2. Now, I think it's our favourite time. We're going to take a quick photo. So if everybody could give me your smile and a wave, that will be great after 3. 1, 2, 3. Perfect. Thank you very much. There's so many of you. I have 3 pages to flick through. Okay, so Nicole, are we ready to open up the breakout rooms?
Yeah, we are indeed. It should take you straight through to them now. Just give me 2 moments.
Perfect. We'll see you all towards the end, and I hope you have a great session.
Thank you.
Thank you.
Thank you.
Thanks.
See you then.
Thanks.
Yeah. Thank you.
For those of you that are still here, there's a couple of you I couldn't move, so we counted the main room as a breakout room as well, so that you can have the conversation here.
Okay. Flavio, I will hand
Yes.
over to you. I will go on mute. Ignore I'm here and have a good session.
Okay. So, good afternoon or good morning. Yes. It's very, very nice to have you here to have this discussion. See some friendly known faces. And well, this is a very interesting point, very interesting topic that they have shown us about this, using as an example. I think that everybody remembers the idea, the Chinese company in each jurisdiction. I think that we can first present oneself and make a quick comment on main aspect on your jurisdiction legislation about the foreign national, a Chinese foreign national, working as a company director, an executive and a non-executive one, if there is a difference, and if one must be an employee or he can work as an autonomous director with no direct link to the company, and any other specification that you may want to stress out. So using an alphabetic order, if we can. I will invite Andrea to start if he wants, obviously. No, he left the room. Yes.
I'm back here.
No, it's Andrea. Andrea, I think that he left. So, Edward, if you want to
Yes.
start, please.
Yes, my jurisdiction is Bermuda, and we can have Chinese directors, and they can be able to visit Bermuda and have as many board meetings as they like. They don't need any piece of paper. They can just travel in and travel out. If they want to stay here, and they would have to apply for a work permit. So the company would have to apply for a work permit. That means they have to have an employment contract for that work permit. The second point is, if the company has a Chinese director, and depending on the business of the company, it will have to decide whether it is appropriate to have economic substance. And that is several categories. If it's a tech company, it might be caught by software patents, IP. But what's going to happen is that a work permit could be for 5 years, or it could be for a year. But that is basically the issues at hand with this case study.
Perfect. Well, I can ask. I think that Dirk is. Oh, Andrea is back on the
Yes,
room.
I'm sorry.
Perfect.
Sorry.
No problem. So, please.
Yes, actually, I'm Andrea Sovranzetti. First of all, to see you again. I'm a partner of a Mexican firm called Carnitz Ortiz y Asociados, and we are also dealing with this kind of issues. I mean, this case specifically of Chinese IT companies, etc., is being handled by several and needs to be handled by several immigration, tax, labor, and compliance risks. Now, for Mexican from the Mexican perspective, here in Mexico, from the general global context, we have clearly we need to distinguish between visitors for performing remunerated activities in Mexico, who must hold a work authorized residence, for example. And from the immigration perspective, obviously, we need to understand how they can be introduced in Mexico as visitors for business purposes, etc. And from the tax perspective, effectively, the tax treaty existing between China and Mexico is very helpful, because it regulates the avoiding of double tax issues between the two countries and for the individual. Okay. And from the labor perspective, it has been analyzed also the work that the director will be performing, the Chinese director, and it shall be introduced and inserted in the bylaws of the company. So there are certain corporate matters that have to be handled.
Perfect. Dirk, c'est à toi. I haven't realized it's Dirk. I'm terrible reading, so as a matter of fact, following the alphabetical order, you should have been the first. But alors, pardonne-moi.
Il n'y a pas de souci, pas de problème. Donc, no, sorry. Actually, I don't even know why we speak French, because I think not everybody speaks French. Just to present myself shortly, I'm, as you see, French, actually German French based in Paris, and we are specialized on tax law. So in regards to the case, we wouldn't treat like typically all that is relevant in terms of immigration, because we would work together with a partner firm who would do this, especially for countries like China, because this is always a little more tricky in France. But we would, and also social security, if it becomes complicated, we would also work with a partner. But what we do is so mainly the taxes. And as most of you, what we would look at first is the double tax treaty in order to figure out, actually, this is the first thing we always do, because we are working a lot with large companies who are regularly sending people to France, and they all have a first interview with us where we, in this interview, we only determine where is their tax residence. Are they going to become a French tax resident, and are they going to be taxed on their worldwide income? Or are they going to stay non-resident during the time they are staying in France? And then, as probably most of you know, we of course analyze the tax treaties. There are the different criteria allowing us to come to a conclusion. We look at the French tax system, and then we determine the tax status, and this allows us then a second time to do all the tax fillings for them as well.
Perfect. Javier, I don't know if Javier is with us. I'm just following the alphabetic order. So, okay, Javier is not with us. So, Oscar, mi amigo, please, it's your turn.
Hello, everyone. It's good to see you, Flavio. Good to see you, Edward, Andrea, Dirk, and Jenny. I think we haven't met before. Javier, for sure we know each other. I think last time I saw you was in Florida, 2020, before the pandemic. But anyway, so I'm in Mexico. I'm the corporate director of Legend. And I was reading these three scenarios.
Sorry, I was in a call. Hi.
No problem.
Hi, Javier.
Hi.
Javier, you lost your opportunity. So I'm sorry.
Sorry, no, okay, I know.
No, you speak after Oscar, obviously.
So, very quick. In Mexico, in 2023, if I remember correctly, there was an amendment to the general corporation laws where annual meetings or partner shareholders meetings and board of directors meetings can be held virtually. So nowadays, there's no need to appoint no one to come to Mexico to sign or to be present for any meeting or board of directors meeting, etc. Obviously, if they want to do it, they can do it, but it's not. If the bylaws of the company allows that kind of virtual sessions, you can hold that virtual session without any problem. Most of the cases in Mexico, we as a representative of these clients or actually shareholders or partners will receive proxies to execute documents on their behalf. According to the law, the management position cannot be executed through a representative. So the board of directors needs to sign documents or need to be present, but now again, based on this amendment to the law, they can hold these resolutions through virtual meetings, and it's allowed according to the law as long as this amendment is contained within the bylaws. In the case of having someone traveling to Mexico, appointing as a managing director, etc., in order for a foreigner to be able to enter in Mexico and to be part of the payroll, in summary, first of all, the Mexican subsidiary needs to be registered before the immigration authorities as an employer of foreigners. It's a process. And then the foreigner needs to run the process, filing a job offer letter for the Mexican company, etc., etc. So the only way to receive a temporary a resident visa from a Mexican company is having the Mexican company hiring directly this foreigner. There's no way to get a visa in that specific situation. And according to the law, there's no need actually to appoint someone. I mean, a member of the board can travel into Mexico to execute whatever board of meeting if they want to be present, etc., etc. When they are entering into Mexico, they're allowed to stay for 180 days, even as a tourist or as a business person. So normally they enter as a business person and they can hold whatever. The only activity that is not allowed under this condition is to receive payment or salary directly from a Mexican company.
Okay.
Hello?
Javier, with you. Yes. Hi.
Hi, Flavio. Flavio, right?
Yes, Flavio.
Flavio, how are you?
I'm quite fine, thank you. So give us your perspective, a quick one about, I think that you have heard about the case, you have read the proposed...
More or less, I mean, sorry, I was taking a call on an urgent matter, but some Chinese that want to travel as tourists, or what? Or what was
No,
the case?
it's a Chinese, you have an IT company in China, and it will send, sorry, the company wants to appoint a Chinese resident, a Chinese national, as a director in your jurisdiction, in your company. Yes. And,
yes.
Sorry. Yeah. And one.
Okay, yes, I got the question. I got the question now. I will answer.
Director. Yes, okay.
All right, I will answer. Thank you, Flavio. Well, it's quite easy. We can appoint a Chinese as a non-resident director. We need a POA from the Chinese individual to obtain a tax ID for him. This POA must be notarized and apostilled, and also a certified copy of the passport. With that, we can get him a tax ID that we get in a minute, in very, very short time. And unfortunately, the Chinese will have to pay Social Security. I mean, we will pay, the company or us, law firm, will pay for him the Social Security contributions for being a director. It's not so steep. It's like, I don't know, $100 per month or $200. It's negligible, the cost of the Social Security contributions for the non-resident director. This is required by tax law. He will be required to travel to your jurisdiction, no problem. For the board meetings, no problem. He can travel. The company, the Chinese, unfortunately, they need a visa to enter into Argentina. If we register the company in the registry of foreign of companies demanding foreign workforce before the immigration authorities, we can invite the Chinese as many times as he wants to participate in the board meetings. Like Oscar mentioned as well, it's very common practice now for the bylaws to allow virtual meetings of the board and virtual meetings of shareholders as well. So the secretary must just record the meetings, but you can participate by Zoom or by other means.
Perfect.
Appointing.
Oh, sorry.
I'm going to question 2 now. No, yes, do I go for question 2?
Yes, please.
Okay. Appointing a Chinese national as managing director for 5 years. Fine. Also, no problem. We need to register the company in this record called RENURE. It's a record in the immigration authorities for companies hiring foreign individuals. And well, of course, the foreign Chinese will have to bring a certificate of criminal records. I mean, he will be a proper resident of Argentina, right? So we need a proper criminal records here. He will get a DNI card that will allow him to travel around Argentina and to neighboring countries such as Brazil, Paraguay, Uruguay and Chile with that DNI, with the ID, with that ID. The individual, this Chinese individual, well, will be the same as an Argentine, subject to taxes, worldwide taxation, income tax, Argentina, high tax. Okay. And question 3. Second, a senior manager from China to the subsidiary for a maximum period of 6 months. Well, again, same solution. We register in the Renure. We invite this person with a letter to the Argentine. It's a letter. It all goes very fast because you send the letter. We have all our relationship with the government is through a website where you make all the filings with digital signature. So you make the invitation and it goes directly the invitation letter to the Argentine embassy in China, in whatever the individual may be. Sometimes it's Hong Kong. Sometimes they are in Singapore. Not always in mainland, but could be also. And with that letter, he can come to Argentina and spend time here. So Flavio, sorry, I was taking another call, but Argentina, I would say it's very flexible. It's very unflexible for other things, but for immigration, it's very easy to come down to Argentina.
Oh, perfect. Well, I will close, this part. I'm Flavio Gugelman from Brazil. I think that I know everybody around, but anyhow, the Brazilian legislation is much simpler than the Mexican and the Argentinian one, but it's very similar at the same time. See, in all 3 scenarios, it doesn't matter if the Chinese national, if it's a Chinese national, sorry, there is no restrictions whatsoever to a Chinese national or to any foreigner to work in Brazil as a director, an executive or a non-executive director. Using that point of view of being an employee or not, the very difference is just the visa, the kind of visa you will have. If you will be an employee director, you will have a work visa. If you will be a non-employee director, you will have a business visa. But there is a consequence on the tax. Being a non-resident in Brazil, obviously, if your country has not, in Chinese specific case, you have a tax law treaty between Brazil and China to avoid being tributed to being taxed 2 times. But anyhow, Brazil will retain all taxes, all income taxes concerned your participation, your revenue, from the company. So it's very interesting that if you are an executive director, you can be represented, you must be, represented in Brazil. You can be a non-resident in Brazil, executive director, but you must have a representative in Brazil with all necessary powers to represent and to run the company on your behalf, on your name, you see? But there are no restrictions applied to your movement. You have the proper visa, you can enter the country as many times as you wish. And the only thing that you must prove, obviously, in the case of being an employee or not, is that you have no criminal records and you have not any deals. If you cannot. There are some countries that Brazil nowadays, as a matter of fact, there are none, because the government has pulled out Brazil from some sanctions against Iran and North Korea. But until 2023, you would not be an employee of a Iranian or a North Korean company. Now there are no restrictions whatsoever, but you cannot be convicted of any kind of crime, of any kind of felony in any jurisdiction. The only and the last point is, and this is very it's the tax point of view. I mean, if you are a non-resident in Brazil, being an employee or not an employee, the best case for you as a person, as a director, is to be a non-employee director, you see, and to the company as well. It will cost the company less if you are a non-employee director. In very short sentences, this is the scenario in Brazil. So what I want to propose you is a question. Is there any nationality in your jurisdiction that cannot work in your jurisdiction? I mean, any national from any part of the world, sorry, that cannot be a director? Are there restrictions applied to any nationalities or another kind of relevant restriction to a foreign national to work in your jurisdiction? So we can start. Yes. No, esto no es cierto. Esto no es cierto. Después nos vamos a pelear por eso.
I'm kidding.
Okay.
No, I mean, we have in Mexico, there are certain restrictions. I don't remember exactly, but we're talking about, I don't remember. I will lie if I tell you, but for sure our immigration area can answer that. But yeah, I don't remember. There are certain restrictions on that. Yeah.
I confirm what Oscar is saying, actually.
Yeah,
I'm not aware of it.
Oh, sorry, Edward.
I'm not aware of any restrictions on nationality. I mean, as you were outlining, a person has to answer no to all these questions about criminal records, etc.
Perfect.
Yes, here in Mexico there is more restrictions. There are restrictions, but not prohibitions.
Perfect. Javier? I think that we lost Javier again. Well, anyhow, in Brazil, I will.
I'm here. Sorry, Flavio. No, I mean, what do you mean restrictions? No, I mean, of course, some countries are more difficult. I don't know, North Korea, for example. I mean, strange passports. We have cases, people from Venezuela that could not issue some documents because Venezuelan authorities were very bad and would not extend, for example, certificate of criminal records, or Russians that were afraid of getting a birth certificate because they were afraid of being called to do the military
service.
Yeah, okay, but no intrinsic restrictions.
Yes, in Brazil, we have no restrictions concerning nationalities. We have restrictions concerning individuals. You must not have a criminal record, obviously, and some individuals that were convicted or persecuted by the International Court of Justice or the Inter-American Court of Justice for certain crimes. So you cannot apply for any kind of Brazilian visa. But foreigners in Brazil, they have no restrictions neither to work nor to buy property, except near the border. Near our borders, foreigners cannot buy land, except Uruguayans, Paraguayans, and Argentinians. They can buy land in the borders because of the Mercosur treaty between our countries. So there are no restrictions applied. We were joined by Eduardo, and he was not here at the beginning. I don't know if he wants to say hi and to share with us his thoughts on the subject. But anyhow, if he wants, just okay. So we have 10 minutes left. I will ask you another question concerning some differences on the not only the salaries but the kind of visa. If you have, for instance, we are talking about a Chinese company that are appointing Chinese nationals to work in your country. If this Chinese company wants to open a subsidiary or a new company in your place, I mean, if they want to buy another company in your jurisdiction, if they have any special regulations or any special rules concerning the partners, concerning if foreigners can hold 100% of the capital, or you have restrictions of such. We can start with Andrea to keep on the
Yes. Yeah, sure. Thank you, Flavio. Actually, according to Mexican law, you can hire a Chinese director or Chinese employee by providing him with a formal letter of employment, and obviously the Chinese individual through the company that intends to hire him needs to proceed to perform certain activities to be regularized in Mexico. For example, he needs to obtain his residence in Mexico. With this residence card, he will be able to obtain his tax ID, to obtain to open his own bank accounts, and thus to start the labor relationship with the Mexican company. So basically, I think that the first step would be for this Mexican company with Chinese capital to perform all the activities required to regularize the individual in Mexico, and then the labor relationship can be performed, can start, provided that the Mexican salaries must be paid in Mexican pesos. This reform was introduced some years ago, and it's mandatory for law.
Perfect. Dirk, s'il te plaît.
Yes. So to be quite honest, we are more of like working with nationalities that are well known. So to answer to your question, can they hold 100% company in France? Yes, normally there's not so much a problem of it, especially not when you're European. When you're outside of Europe, for most of the countries, as I know of, no. There might be some little tricky questions with countries like Russia or North Korea, where it can be more difficult, but I have to admit that I've never worked for this, so I cannot give you the answer to this question.
Perfect. Edward, please.
Yes. Basically, the company buying another company in our jurisdiction, the first question is the company they're buying a local company or an exempt company? A local company can only have 40% of its shares owned by someone overseas, except a few exemptions which you can apply for, like banks can have overseas control. If that question is answered, you would then have to go to a corporate service provider who would then be given the documentation as to who the overseas owners are and get permission from the Bermuda Monetary Authority to have those registered as ultimate beneficial owners. And then they could go forward and own the company. And that process takes as long as it takes to get the documentation to show who the owners are. Obviously, there's exemptions if the company is a public company on a recognized stock exchange, but that's basically how they would buy an overseas company.
Perfect.
Sorry,
Javier? Oscar? you can give us your.
Yeah, so just refresh my mind. We're talking about the acquisitions, whether there are limitations.
No, just if you have any restrictions of foreigners holding the whole company by
Yeah, I
any
got
kind
it.
of
Yeah,
restrictions.
there are, according to the Mexican foreign investment law, there are activities reserved for the Mexican government. There are other activities where the foreign investment can participate 49%, 51 Mexicans, and certain activities where the foreign investment can participate 100%. The foreign investment law sets what are those activities. In the case of the clients we assist, all of them are 100% investing in Mexico, so there are no limitations regarding owning a capital stock. There are no limitations regarding members of the board. Owners of the companies, shareholders, partners can be individuals, nationals, foreigners, companies, nationals, foreigners. So there's no restriction except for that specific activities.
Perfect. Javier?
Sorry, I was muted, Flavio.
So the restrictions in Argentina concerning foreigners owning companies. You have any restrictions?
No restrictions. No restrictions. Like I was saying, sorry, I was muted. The only very, like, I think most of the countries, like you mentioned in Brazil, we have a problem, not a problem, but a different filing with border zones. So 20 kilometers from the border, you need to ask for a specific approval. Well, for security reasons, you don't want, I don't know, a foreign national of a country with whom you may have problems. Our friends from Chile, I mean, we had problems in the border, and they have to ask for permission, but nothing else.
Yes, in Brazil, we have.
Quick question, Javier. So is that for owning property, real estate? Is that correct? You're muted.
Yeah, you are muted.
You're muted.
El micrófono.
Sorry. It's owning property, or own. It's all, it goes all the way. You go to the UBO, or owning companies that own property in the border zones, or trust, or any.
Got it.
Anything complex structure that you want to set. If at the end there is a foreign national, you must report. Okay.
We in Brazil, it's very much like in Mexico, but much simpler. I mean, we have very few activities where foreigners cannot hold the whole company, like in mineralogy and aviation, and in some military industries connected to the national defense. But a foreigner can participate, but he cannot be the responsible, neither the main shareholder nor the president or the main executive of this company. It's very similar to Mexico. But the only difference between Brazil and Mexico is that we have no activity, no economic activity that it's 100% owned by the government. You see, unlike Mexico. Well, pretty much, I think that we are out of time. Let me see if Jenny, yes.
Yes.
So thank you very much. Merci.
Yes, so
Gracias.
Thank you very much, Flavio, for hosting that room. I was listening in and there was some very good discussions going on. So I believe everyone is coming back into the main room now. Shortly, I will hand over to the committee just to have a final recap. But again, I just wanted to thank Blue Manthal, the sponsors of the virtual event. Also to remind you, if you haven't registered for any more sessions, take a look. There are a few more coming up throughout the week. If they're of interest to you, along with signing up for the conferences. So I am going to hand over to the committee now. Tommaso, Akim, Graham, Christina and Stephanie and Kavita, if you would like to have a recap of the session.
Anybody? Well, I'm happy to. We certainly had a fascinating discussion that was extremely wide-ranging, and I think if we could have gone into a lot more depth, but it does illustrate the range of subjects that come within the field of global mobility. So I think it's a good way of sort of publicizing the existence of the group and hopefully generating more and more interest. Whether others would like to comment?
Thank you, Graham.
Yeah, well, it was indeed very interesting. Sorry. I was wondering, but I am asking widely, if we could ask all the people that attended today their thoughts and what they would like to see in the future virtual sessions that we would like to host, because obviously we have lots of things to do to talk about and to share. But the idea is really to have you all very interested in what we discuss. So yeah, we'll probably organize something with Jenny to know about your thoughts.
Great idea.
Sure.
Yes. What I will do as well, tomorrow morning, I will send an email to everyone that has joined today. You will have the attendee list along with screenshots of the session that you can share on your LinkedIn pages. I will tag as many of you in as I can as well on LinkedIn. And again, if anyone has ideas for another virtual session, send me an email. I'll shortly be writing out to the group as well to get the next session booked in for the year. So yes, any ideas are very welcomed to the group. Okay.
Great. Thank you, Jenny.
Okay, perfect.
Thank you.
Well, if that is all, thank you to everyone that has joined today. As I said, you will receive that email tomorrow, and I hope you all enjoy the rest of your day. Thank you very much.
Thank you.
Thank you, everybody.
Thank you.
Bye.
Bye.
It's been wonderful.
Bye-bye.
Thank you very much.
You're welcome. Thank you.